Without objection, the gentleman is recognized.
Mr. Speaker, I'd like to thank the gentleman from Pennsylvania, Mr. Meehan, for his work in crafting this legislation and for bringing it to the floor. This, too, is one of the important things that we need to do to restore some trust and confidence and accountability at the Internal Revenue Service. And for the purpose of describing the legislation, I'd like to yield such time as he may consume to Mr. Meehan.
The gentleman is recognized.
Thank you, Mr. Speaker, and I thank the chairman for his recognition and his support of this very, once again, thematically important bill. I rise today in support of what's common sense legislation, H.R. 1314, and what it does is gives tax-exempt status applicants whose application is denied the right to appeal that decision. That seems fundamental, doesn't it? In a country like ours, a Constitution that builds within it the concept of the right to petition your government for the decisions that they make. The purpose of the legislation is simple. What it will do is codify in statute the requirement for the IRS to create a mechanism by which 501c3 or 501c organizations, tax-exempt organizations, if they get an adverse determination of their tax-exempt status, they can request an administrative appeal to the agency's Internal Office of Appeals. My colleague from Illinois talked about the concept here of impunity. And to me, this is a lot of what this speaks to. The idea that an administrative agency, in this case the IRS, would take this application and then would make a decision, and it was because of the good work that was done in the previous Congress by this committee and the oversight subcommittee of this committee, that they exposed the reality that in many cases these particular appeals, these particular decisions were being made after the applicant was being targeted because of the fact that they had chosen to express particular political views in the context of their application. What was done was those applications, once denied, were diverted to a different part of the structure in which they went to die. And that made the IRS, the judge, the jury, and in fact, the executioner, because you were done with respect to your application. There was no place else to go. Now, I have to say that when this came to the light, because of the work of this committee, the IRS did issue interim guidance on May of 2014 that ensured that all groups subject to a denial would have a right to appeal the decision. But this bill today, H.R. 1314, codifies that guidance into law. So there's no ambiguity. And once again, we don't have the ability of the IRS to indiscriminately and sua sponte make their own decisions about when American taxpayers should have the right to be able to petition for an appeal of an adverse decision. Mr. Speaker, I ask unanimous consent to enter into the record a letter from the Small Business and Entrepreneurship Council which supports the legislation. And the group writes that H.R. 1314 is an important bill as it allows taxpayers an additional right to petition their government when they disagree with a decision. That's the fundamental challenge that we have to the impunity which has been taking place. And I urge my colleagues, as they have on our subcommittee and on our committee with their unanimous support on our committee from both sides of the aisle, to support this common sense taxpayer protection and to send an unmistakable signal to the American taxpayers that they should not be targeted by the IRS for their political views. Mr. Speaker, I yield back.